At-will employment is a term used in U.S. labor law for contractual relationships in which an employee can be dismissed by an employer for any reason, and without warning. When an employee is acknowledged as being hired at will, courts deny the employee any claim for loss resulting from the dismissal. The rule is justified by its proponents on the basis that an employee may be similarly entitled to leave his or her job without reason or warning. In contrast, the practice is seen as unjust by those who view the employment relationship as characterized by inequality of bargaining power. At-will employment gradually became the default rule under the common law of the employment contract in most states during the late 19th century, and was endorsed by the U.S. Supreme Court during the Lochner era, when members of the U.S. judiciary consciously sought to prevent government regulation of labor markets. Over the 20th century, many states modified the rule by adding an increasing number of exceptions, or by changing the default expectations in the employment contract altogether. In workplaces with a trade union recognized for purposes of collective bargaining, and in many public sector jobs, the normal standard for dismissal is that the employer must have a just cause. Otherwise, subject to statutory rights, most states adhere to the general principle that employer and employee may contract for the dismissal protection they choose. At-will employment remains controversial, and remains a central topic of debate in the study of law and economics, especially with regard to the macroeconomic efficiency of allowing employers to summarily and arbitrarily terminate employees. Definition: At-will employment is generally described as follows: any hiring is presumed to be at will. That is, the employer is free to discharge individuals for good cause, or bad cause, or no cause at all, and the employee is equally free to quit, strike, or otherwise cease work. In an October 2000 decision largely reaffirming employers' rights under the at-will doctrine, the Supreme Court of California explained, at-will employment disclaimers are a staple of employee handbooks in the United States. It is common for employers to define what at-will employment means, explain that an employee unregistered trademark at-will status cannot be changed except in a writing signed by the company president, and require that an employee sign an acknowledgement of his or her at-will status. History: the original common law rule for dismissal of employees according to William Blackstone envisaged that, unless another practice was agreed, employees would be deemed to be hired for a fixed term of 1 year. Over the 19th century, most states in the North adhered to the rule that the period by which an employee was paid determined the period of notice that should be given before a dismissal was effective. For instance, in 1870 in Massachusetts, Tatterson v. Suffolk MFG Company held that an employee's term of hiring dictated the default period of notice. By contrast, in Tennessee, a court stated in 1884 that an employer should be allowed to dismiss any worker, or any number of workers, for any reason at all. An individual, or a collective agreement, according to the general doctrine of freedom of contract, could always stipulate that an employee should only be dismissed for a good reason, or a just cause, or that elected employee representatives would have a say on whether a dismissal should take effect. However, the position of the typical 19th-century worker meant that this was rare. The at-will practice is typically traced to a treatise published by Horace Graywood in 1877, called Master and Servant. Wood cited 4 U.S. cases as authority for his rule that when a hiring was indefinite, the burden of proof was on the servant to prove that an indefinite employment term was for 1 year. In Toussaint v. Blue Cross and Blue Shield of Michigan, the court noted that Wood unregistered trademark S rule was quickly cited as authority for another proposition. Wood, however, misinterpreted 2 of the cases which in fact showed that in Massachusetts and Michigan, at least, the rule was that employees should have notice before dismissal according to the periods of their contract. In New York, the first case to adopt Wood's rule was Martin v. New York Life Insurance Company in 1895. Bartlett J. asserted that New York law now followed Wood's treatise, which meant that an employee who received $10,000, paid in a salary over a year, could be dismissed immediately. The case did not make reference to the previous authority. 4 years earlier, in 1891, Adams v. Fitzpatrick had held that New York law followed the general practice of requiring notice similar to pay periods. However, subsequent New York cases continued to follow the at-will rule into the early 20th century. Some courts saw the rule as requiring the employee to prove an express contract for a definite term in order to maintain an action based on termination of the employment. Thus was born the U.S. at-will employment rule, which allowed discharge for no reason. This rule was adopted by all U.S. states. In 1959, the first judicial exception to the at-will rule was created by one of the California Courts of Appeal. Later, in a 1980 landmark case involving ARCO, the Supreme Court of California endorsed the rule first articulated by the Court of Appeal. The resulting civil actions by employees are now known in California as terminate actions for wrongful termination in violation of public policy. Since 1959, several common law and statutory exceptions to at-will employment have been created. Common law protects an employee from retaliation if the employee disobeys an employer on the grounds that the employer ordered him or her to do something illegal or immoral. However, in the majority of cases, the burden of proof remains upon the discharged employee. No U.S. state but Montana has chosen to statutorily modify the employment at-will rule. In 1987, the Montana legislature passed the Wrongful Discharge from Employment Act. The WDEA Act is unique in that, although it purports to preserve the at-will concept in employment law, it also expressly enumerates the legal basis for a wrongful discharge action. Under the WDEA, a discharge is wrongful only if it was in retaliation for the employee's refusal to violate public policy or for reporting a violation of public policy. The discharge was not for good cause and the employee had completed the employer's probationary period of employment, or the employer violated the express provisions of its own written personal policy. It is important to understand that the at-will doctrine is merely a default rule that can be overridden by an express contract or civil service statutes. As many as 34% of all U.S. employees apparently enjoy the protection of some kind of just cause, or objectively reasonable requirement for termination that takes them out of the pure at-will category, including the 7.5% of unionized private sector workers, the 0.8% of non-union private sector workers protected by union contracts, a 15% of non-union private sector workers with individual express contracts that override the at-will doctrine, and the 16% of the total workforce who enjoy civil service protections as public sector employees. Public policy exceptions. Under the public policy exception, an employer may not fire an employee if it would violate the state's public policy doctrine or a state or federal statute. This includes retaliating against an employee for performing an action that complies with public policy, as well as refusing to perform an action that would violate public policy. In this diagram, the pink states have the exception, which protects the employee. As of October 2000, 42 U.S. states and the District of Columbia recognize public policy as an exception to the at-will rule. The 7 states which do not have the exception are Alabama, Georgia, Louisiana, Maine, Nebraska, New York, Rhode Island, Florida. 3 limited conditions can override an at-will agreement, implied contract exceptions. 36 U.S. states also recognize an implied contract as an exception to at-will employment. Under the implied contract exception, an employer may not fire an employee, when an implied contract is formed between an employer and employee, even though no express, written instrument regarding the employment relationship exists. Proving the terms of an implied contract is often difficult, and the burden of proof is on the fired employee. Implied employment contracts are most often found when an employer's personal policies or handbooks indicate that an employee will not be fired except for good cause or specify a process for firing. If the employer fires the employee in violation of an implied employment contract, the employer may be found liable for breach of contract. 36 U.S. states have an implied contract exception. The 14 states having no such exception are Arizona, Delaware, Florida, Georgia, Indiana, Louisiana, Massachusetts, Missouri, Montana, North Carolina, Pennsylvania, Rhode Island, Texas, Virginia. The implied contract theory to circumvent at-will employment must be treated with caution. In 2006, the Texas Court of Civil Appeals in Matagorda County Hospital District v. Burrell held that a provision in an employee handbook stating that dismissal may be for cause, and requiring employee records to specify the reason for termination, did not modify an employee's at-will employment. The New York Court of Appeals, that state unregistered trademark's highest court, also rejected the implied contract theory to circumvent employment at will. In Anthony Labosco, Appellant v. New York Telephone Company NYNEX, Respondent, the court restated the prevailing rule that an employee could not maintain an action for wrongful discharge where state law recognized neither the tort of wrongful discharge, nor exceptions for firings that violate public policy, and an employee's explicit employee handbook disclaimer preserved the at-will employment relationship. And in the same 2000 decision mentioned above, the Supreme Court of California held that the length of an employee's long and successful service, standing alone, is not evidence in and of itself of an implied in fact contract not to terminate except for cause. Covenant of good faith and fair dealing exceptions. 11 U.S. states have recognized a breach of an implied covenant of good faith and fair dealing as an exception to at-will employment. These 11 states are, Alabama, Alaska, Arizona, California, Delaware, Idaho, Massachusetts, Montana, Nevada, Utah, Wyoming. This exception for a covenant of good faith and fair dealing represents the most significant departure from the traditional employment at will doctrine. Rather than narrowly prohibiting terminations based on public policy or an implied contract, this exception at its broadest reads a covenant of good faith and fair dealing into every employment relationship. It has been interpreted, by some courts, to mean either that employer personnel decisions are subject to a just cause standard or that terminations made in bad faith or motivated by malice are prohibited. Statutory exceptions. Although all U.S. states have a number of statutory protections for employees, most wrongful termination suits brought under statutory causes of action use the federal anti-discrimination statutes which prohibit firing or refusing to hire an employee because of race, color, religion, sex, national origin, age, or handicap status. Other reasons an employer may not use to fire an at-will employee are, for refusing to commit illegal acts. An employer is not permitted to fire an employee because the employee refuses to commit an act that is illegal. Family or medical leave. Federal law permits most employees to take a leave of absence for specific family or medical problems. An employer is not permitted to fire an employee who takes family or medical leave for a reason outlined in the Family and Medical Leave Act of 1993. Not following own termination procedures. Often, the employee handbook or company policy outlines a procedure that must be followed before an employee is terminated. If the employer fires an employee without following this procedure, the employee may have a claim for wrongful termination. Examples of federal statutes include, Equal Pay Act of 1963, Title VII of the Civil Rights Act of 1964, Age Discrimination in Employment Act of 1967, Rehabilitation Act of 1973, Americans with Disabilities Act of 1990. The National Labor Relations Act provides protection to employees who wish to join or form a union and those who engage in union activity. The Act also protects employees who engage in a concerted activity. Most employers set forth their workplace rules and policies in an employee handbook. A common provision in those handbooks is a statement that employment with the employer is at will. In 2012, the National Labor Relations Board, the federal administrative agency responsible for enforcing the National Labor Relations Act, instituted 2 cases attacking at-will employment disclaimers in employee handbooks. The NLRB challenged broadly worded disclaimers, alleging that the statements improperly suggested that employees could not act concertedly to attempt to change the at-will nature of their employment, and thereby interfered with employers' unregistered trademark protected rights under the NLRA. In 2012, Region 28 of the National Labor Relations Board, located in Arizona, attempted to outlaw the practice of including at-will employment disclaimers in employee handbooks by finding such at-will provisions unlawful under the National Labor Relations Act. Arizona Region 28 case, American Red Cross Arizona and Lois Hampton addressed the unlawful waiver of NLRB rights, and a second case, Hyatt Hotels Corporation and Untitled International Union, addressed the settlement of claims. In addition to being fired based on status in a protected class, employers are not allowed to retaliate against any protected action. Protected actions include suing for wrongful termination, testifying as a witness in a wrongful termination case, or even opposing what they believe, whether they can prove it or not, to be wrongful discrimination. In the recent federal case of Ross v. Vanguard, Raymond Ross successfully sued his employer for firing him due to his allegations of racial discrimination. Controversy. On the one hand, the doctrine of at-will employment has been heavily criticized for its severe harshness upon employees. It has also been criticized as predicated upon flawed assumptions about the inherent distribution of power and information in the employee-employer relationship. On the other hand, conservative scholars in the field of law and economics such as Professors Richard A. Epstein and Richard Posner credit employment at will as a major factor underlying the strength of the U.S. economy. At-will employment has also been identified as a reason for the success of Silicon Valley as an entrepreneur-friendly environment. In a 2009 article surveying the academic literature from both U.S. and international sources, University of Virginia law professor J. H. Vercook explained that although everyone agrees that raising firing costs must necessarily deter both discharges and new hiring, predictions for all other variables depend heavily on the structure of the model and assumptions about crucial parameters. The effect of raising firing costs is generally accepted in mainstream economics. For example, Professors Tyler Cowen and Alex Tabarrok explain in their macroeconomics textbook that employers become more reluctant to hire employees if they are uncertain about their ability to immediately fire them. The first major empirical study on the impact of exceptions to at-will employment was published in 1992 by James N. Derpizos and Lynn A. Carley of the Rand Corporation, which found that recognizing tort exceptions to at-will could cause up to a 2.9% decline in aggregate employment, and recognizing contract exceptions could cause an additional decline of 1.8%. According to Vercook, the Rand paper received considerable attention and publicity. Indeed, it was favorably cited in a 2010 book published by the libertarian Cato Institute. However, a 2000 paper by Thomas Miles found no effect upon aggregate employment but found that adopting the implied contract exception causes use of temporary employment to rise as much as 15%. Later work by David Autor in the mid-2000s identified multiple flaws in Miles' methodology, found that the implied contract exception decreased aggregate employment 0.8 to 1.6%, and confirmed the outsourcing phenomenon identified by Miles, but also found that the tort exceptions to it will have no statistically significant influence. Autor and colleagues later found in 2007 that the good faith exception does reduce job flows, and seems to cause labor productivity to rise but total factor productivity to drop. In other words, employers forced to find a good faith reason to fire an employee tend to automate operations to avoid hiring new employees, but also suffer an impact on total productivity because of the increased difficulty in discharging unproductive employees. Other researchers have found that at-will exceptions have a negative effect on re-employment of unemployed workers, and that hedonic regressions on at-will exceptions show large negative effects on individual welfare with regard to home values, rents, and wages. Vercook also explains that several international comparative studies have found that job security has a large negative effect on employment rates. See also, Employment Rights Act 1996, for the UK approach to employment protection. See also, Contracts of Employment Act 1963, for the first modern UK law on the requirement to give reasonable notice before any dismissal. Crean v. Wright LR 1 CPD 591 and Hill v. C. Parsons and Company, 1972, 1 CH 305, Employment Agency, European Social Charter, UK Agency Worker Law, Worker Adjustment and Retraining Notification Act, Bammett v. Don Supervalub, Incorporated, 646 NW2D 365, Notes. References, C. W. Summers, the contract of employment and the rights of individual employees, fair representation and employment at will, unregistered trademark 52, 6, Fordham Law Review 1082, external references. This article incorporates a public domain material from the United States government document The Employment at Will Doctrine, 3 Major Exceptions by Charles J. Moule, U.S. Bureau of Labor Statistics. Housestone v. Western Engineering, Incorporated, No. 98 to 1548 at will relationship must be clear to the employees,